I have final legal decision making over my kids specifically for medical issues. Yet I cannot get a counselor to see me because they are still requiring that my ex sign the paperwork consenting for counseling. What can I do? This is a humongous pet peeve of mine. My name is Billy Tarasio. I'm an Arizona family law attorney, and I can't tell you how many of my clients have had this problem where they've said counselors won't see my kids even though I have the legal authority to sign up my kids. And they say it's because that's what the law says. Well, that's not what the law says. Let's talk about it. There are two relevant statutes on point. We're going to talk about both of them. The first is Section ARS 362272, and it says consent of a parent required for mental health screening or treatment of minors. It begins by saying, except as otherwise provided by law or court order. Let's just stop right there. If you have final legal decision making or sole legal decision making, you have a court order. So the person interpreting this statute needs to look at your court order. But let's continue. No person, corporation, association, organization, or state-supported institution or any individual employed by these entities may procure, solicit to perform, arrange for the performance, or perform mental health screening in a non-clinical setting or mental health treatment on a minor without first obtaining the written or oral consent of a parent or a legal custodian of the minor child. This statute is designed to prevent non-parents from determining that children need mental health treatment or people allowing children to go get their own mental health treatment without their parents' consent. It does not require both parents' signature. It certainly doesn't require anything different for divorced parents than for parents who are married. So this statute cannot be used for a counselor or therapist to say that it is the basis to deny your ability to get your kids mental health treatment. Let's look at the other statute. It is 25-403-06, parental access to prescription medication and records. And it says, unless otherwise provided by the court or law, on reasonable request, both parents are entitled to have equal access to prescription medication, documents, and other information concerning the child's education, physical, mental, moral, emotional health, including medical, school, police, court orders, and other things related. Okay? So everybody gets access to information. That is what this statute says, nothing more. The last section of this statute says a parent who attempts to restrict the release of documents or information or withhold prescription medication is subject to appropriate legal sanctions. So this statute, I think, could be used to say by a counselor, if you want safe haven counseling, which means both parents agree not to have the records released directly to the parents so that the children can speak freely, that I believe could require signatures of both parents because this statute says everybody gets the right to see your children's records. So that in that case, if you're looking for safe haven counseling, then I do believe that it would be appropriate for a counselor to request signatures of both parents. But if we're just talking access to treatment, I don't believe that there is any statute on point in Arizona that would allow counselors to deny you getting your children mental health treatment. It comes up again and again and again and again, and it's one of these things where you're going to have to figure out how to advocate for your children and also educate the providers and practitioners because they're going off of their policies. What does this mean in all practicality? It means, in my opinion, that either parent has the ability to authorize mental health treatment. If you have joint legal decision making and one of those parents refuse consent and that parent revokes consent directly to the provider, then I believe the provider probably has to stop providing treatment until a court order gives one parent final legal decision making. I do not believe that the mental health provider has liability for providing counseling or mental health records as long as one parent has given consent per the law.